Hello and welcome to the first Global Experts Plenary of this CISDL's Biennial Symposium, The Natural World, the Sustainable Development Goals, and the Law. My name is Gwyneth Boone, and I am currently a BCL JD candidate at McGill University and a researcher with the Center for International Sustainable Development Law. I will serve as one of your moderators in this plenary.
Hello, and welcome to all of our participants. My name is Dr. Antoinette Nestor. I serve as manager of the Climate Law and Governance Initiative based at the Center for International Sustainable Development Law, and together with my co-moderator, it is my pleasure to introduce the chairs of our first Global Experts Plenary, linking human rights and climate change through international law. Ayman Cherkaoui is Lead Counsel Climate Change at the Center for International Sustainable Development Law. He serves as the Deputy Chair of the IUCN World Commission on Environmental Law and previously served as the legal advisor to the COP22 presidency and as a special advisor to the COP23 presidency. He's Director Hassan to International Center for Environmental Training and coordinator of the Mohammed VI Prize for the Climate and Sustainable Development. And Dr. Ashfaq Khalfan is Chair, Board of Governors at the Center for International Sustainable Development Law and Oxfam America's Director of Climate Justice. He was previously the Director of Law and Policy at Amnesty International. Dr. Khalfan has also authored or co-authored a number of impressive academic publications and commentaries on topics related to sustainable development. Over to you.
Hello, everyone, and thank you for joining us. So together with Ayman, I'll be the chair for this plenary. And it's my pleasure to introduce the keynote speakers for this session. So Ambassador Dessima Williams and Justice Jawad Hassan. Ambassador Williams serves as Special Advisor for the implementation of the Sustainable Development Goals. And you'll see she has the pin for that, as well as a few others on this call, in the Office of the President of the United Nations General Assembly. Ambassador Williams has served at various times as Grenada's representative to the Organization of American States, Deputy Governor to the World Bank, and Deputy Permanent Representative to the Inter-American Commission of Women. So she's also been the ambassador of Grenada to the UN, and for part of that time as chair of the Alliance of Small Island Developing States. Justice Hassan is a judge of the Lahore High Court in Pakistan. He is an expert on public and private international law and has been involved in legislative and judicial reforms on issues ranging from child labor, domestic workers, and environmental rights, as well as publishing widely in this field. He's been a pioneer of environmental justice in Pakistan and has been for a long time an advocate for the judiciary's pivotal role on climate justice. So over to you, Ambassador Williams.
Thank you very much, and greetings across the world to everyone viewing and participating. Much of what you read is in the past. I'm not at the United Nations. I'm not working on SDGs. At the end of my talk, maybe I'll tell you what I'm doing now. So in 5 minutes I have, yes. Let me just say that, I presented a 20-minute talk, so let me think it quickly in 5. I think it is true. Greetings, everyone, and thank you for inviting me. It is true, as our conference material says, that law and policy can foster sustainability. We know that. But it is equally true that at the legal, policy, and at the practical levels, the world faces complexities regarding the implementation of the world's most recent rendition of collective sustainability, which is the Agenda 2030 with the Sustainable Development Goals. Now, so the Sustainable Development Goals really are the anchor. They constitute the anchor around which law and policy are attached, but also I would say that they make possible our understanding and our actions around climate change, and vice versa. So perhaps I will focus on the SDGs that way. The recent report, SDG report, which is the most comprehensive global assessment of Progress says in its 2024 version, and in the words of the UN Secretary General Guterres, that, and I quote, "The world is getting a failing grade regarding the SDGs. Only 17% of the SDG targets are on track. Development," he says, "is being undermined." There's a little good news, and that there is progress for women, there's progress with disease control, there's progress with internet usage, solar spreading, but overall 17% is not a passing grade. Serious underperformance with glimmers of hope. So if the world wishes to go in that direction with the 6 years that are remaining for their implementation, what are we to do? What can be correctives? What are some of the foci points? Well, I think we've got a whole range of tools. You know, I'm abbreviating terribly here. So we've got all these tools, I would say two clusters, two generations. The first one is the human rights frameworks, which gave us in the 1948 period, gave us, among others, the United Nations Charter, the Universal Declaration of Human Rights, and others that constitute sort of the human rights anchor, as I said. And then the second one started in and around 2015, and we have a battery there. We have the Agenda 2030 and the SDGs. We have the Paris Agreement, the Sendai Agreement, the Financing for Development, the Samoa Agreement. Now, all of this you all know, but you may not remember that the Samoa Agreement, which focuses on the small island developing states, and there are others for unique categories of groups of states, that Samoa Agreement, which has recently been updated by the ABAS, the Antigua and Barbuda Agenda for Sustainable Development for Small Island States. These are intended to place particular focus, if not ramp up action, on regarding the SDGs for the islands. So I would say that these tools, these conventions, some that are legal, like the Paris Agreement, some that are really not legal, they're more global policy frameworks. They are intended as protection against various vulnerabilities, and they are intended to help us build resilience, to make progress, to keep a momentum toward progress on an agenda for the globe. They're also, by having them, we have raised the global alarm on human rights, either lack of attainment or abuses. They have established norms and thresholds that we should live by as governments, as societies. And they have helped to clarify expectations. You know the famous debates, let's say, between 2 degrees and a 1.5 world. So I think we already know all of this. My contribution on them now is to say that we've got to take them all together for them to make sense, and for us to make progress, that they're interconnected. Not just the SDGs themselves are interconnected, but Paris Agreement and SDGs are interconnected. Samoa Agreement, or ABAS, is connected to the SDG framework. So for example, legal action, climate action, which is SDG number 13, makes more sense when taken with the Paris Agreement, and on and on. I also want to say that when we take them all together, they focus on certain groups, and here for me, the small island developing states, which also speak about climate change and sustainable development.
Ambassador.
I run out of time? Have I run out of time?
Yes, thank you. Maybe just to conclude.
Yes, so to conclude, there are a number of initiatives globally. Many cases are being brought. The law is being yielded more and more in the interest of sustainability. And I think that that's a trend, that's one direction that is of value in meeting the goals of the SDGs, albeit sometimes simply around climate change. And the developing countries are in that activity. Thank you.
Sorry, I think somebody hadn't muted. But if you can continue concluding, please, Ambassador.
Well, thank you. I simply want to say that I think it is clear that the islands and the rest of the world need to do a lot of work. We have the tools towards sustainability. The question is, are they strong enough? Are they robust enough? Do we need more legal commitments like the Paris Agreement? Are the policy frameworks and the human rights frameworks not sufficient or are not being adequately adhered to? It's clear that the climate change violates human rights, including the right to life, the right to food, and so on. Law and policy are often designated to improve that, but maybe gaps exist as well as the practical complexities. In my own country, we just had, on July 2nd, we just had a Category 5 hurricane, which devastated parts of our nation. We are a small archipelago, and some of our smaller islands and some of the northern parts are completely devastated, Category 5. What's going to be of support is if we could see the active implementation of some of the commitments that we already have. And in closing, let me say that I now sit as the president of the Senate in Grenada, and I want to, as a legislator, make sure that we are able to evaluate and find use in these tools as we seek to rebuild. Thank you.
Thank you very much. And that's a good segue to Justice Hassan to talk about filling in the gaps. Justice Hassan.
Good afternoon. I think the most important topic now is the issue how to tackle the climate justice and sustainable development with climate finance. We have spent almost 50-60 years talking about what the topic is, human rights and the linkage with the climate justice. Human rights is well established and that both are interconnected with the climate justice. But now what the issue, I've been speaking in London, yesterday I was in Durham Law School, same issue which is coming out is how we should tackle the climate justice through the climate finance, and whether the climate finance can be dealt by the environmental courts or can be dealt by the commercial courts. They both have a very interdependent and critical relationship, which is called symbiotic. And the issue now is that we have been speaking about same subject for almost 40-50 years ago, which was called environmental nuisance. Then we said environmental just protection, then environmental management, environmental conservation, then it came environmental justice, then it came climate justice. Now it's serious time to talk about how to control the damage is through climate finance. Jeff is going to fund, there's some multilateral countries should fund, and how the world will look at it when the world is going to give money, because I am speaking from Pakistan's behalf, because there are 8 million people displaced because of floods. We are at the receiving end. What happened to Pakistan was the main issue was that they all are, as my topic today is how human rights are linked with the climate justice. And my topic is that they are interconnected because Article 9, a right to life, right to environment, right to a property, right to a dignity, right to home is all linked with what is happening with the world disasters. So how you should deal with this is the issue will be looking at the examples of what happened in Ecuador, what's happening in the countries when they are financing some funding for adaptation as per climate Paris Agreement, funding for mitigation, again as Paris Agreement. But what is a legal framework? There's not a single legal framework, although countries are right now thinking of making some kind of internal legal framework through the Security and Exchange Commission, to their central banks to have the green financing, and only need for the whole world to now look at it when the donors, multilateral banks, even JEF, or any other countries are giving money to now tackle the environmental issue or the climate issue. How will they be secure? What is the dispute resolution mechanism? How the matter be resolved, because they all be funding as funding under the commercial law. And whether now we were seeing in London whether commercial courts can deal with that issue, commercial or the environmental court has jurisdiction, whether the High Court has jurisdiction. Now the issue is funding is going to be coming now. Which court will handle, under which legal framework? This is something we should think about. And I think I have, that's I want to say in more than 4 minutes. Thank you.
Thank you. Thank you very much indeed to both of you, Ambassador Dessima Williams and Justice Jawad Hassan, for your compelling remarks. You mentioned the importance inter alia of clarifying expectations, legislation, climate justice, and climate finance. You also set forward an important direction. Our expectations were high and you met them in your remarks. Just make sure to follow the important direction that you set for us. To do that, we have a set of amazing speakers, and we also have 3 focus questions. Of course, we'd like to invite each of you, dear participants, to also put in questions for our speakers in the chat using the Q&A function. So the 3 focus questions are: question 1, how does human rights law respond to the climate emergency? Question 2, how does international law on climate change and human rights advance the global sustainable development goals? Question 3, what has been the most recent developments in climate litigation worldwide, and what are some of the challenges and opportunities? So we'll have 5 leading experts in the field to address those questions. In the interest of time, I'll introduce all of them right away. Professor Richard Walsgrove is an associate professor of law at the University of Hawaii at Manoa William S. Richardson School of Law. He specializes in environmental law, climate change, and energy policy. Professor Ashinti Vichanath is a professor of law at Pace University's Elizabeth Hobbs School of Law and has been recognized as a leading environmental and energy lawyer in the United States. Professor James R. May is Distinguished Professor of Law at Widener University, Delaware Law School, and founder of the Global Environmental Rights Institute. He's a prolific author, having written and co-edited multiple books. Advocate Zuneida Musa Wadiwala is an associate fellow at the Center for International Sustainable Development Law and an admitted attorney, a conveyancer, and notary of the High Court of South Africa. Advocate Lara Duvastasis is a senior legal executive with the Net Zero Lawyers Alliance, an associate fellow at the Center for International Sustainable Development Law. She has also served as associate to the Chief Justice of the Supreme Court of South Australia. So I'll be going in reverse order in terms of the speakers and asking Advocate Lara Duvarta, sorry for mispronouncing your last name, I'll give it another shot, slower, Duvartidis, to please start us off with her response to how does human rights law respond to the climate emergency. Thank you.
Perfect. Thank you so much, Ayman, and thank you to everyone for making this day possible. I have 3 minutes, so I will utilize them effectively. To answer your question, Ayman, firstly, what is human rights law, and particularly what is the International Bill of Rights? So for everyone, it is 3 things. It is the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the International Covenant on Economic, Social, and Cultural Rights. And together they form the Bill of Rights alongside a number of other covenants, which a lot of you would be familiar with. With that, we've seen a greening of these instruments, but we also have seen the introduction of a number of individual responses. So Just to remember that a state and a government's duties under international human rights law is to respect human rights, to fulfill human rights, and to protect human rights. And of course, every human right is affected by climate change. So what are the individual responses? We've had the creation of new special rapporteur mandates, and special rapporteurs are tasked with individual mandates. We saw the introduction of a human rights and environmental mandate, which was in March 2012. That was extended in 2018 and will likely be extended again. We also saw in 2021 the creation of a special rapporteur on the promotion and protection of human rights in the context of climate change, which for a lot of us was an exciting and very necessary step. In 2022, Professor Ian Fry was the first special rapporteur, and he's just finished. We will hear from him later today, and there is a new special rapporteur on that mandate because it's been extended. In July 2022, another human rights response to the climate emergency was the seeing of a adoption of a General Assembly resolution recognizing the right to a clean, healthy, and sustainable environment as a human right. And with that, there was 161 votes for, and I think there were 8 abstentions. They called for greater global efforts to ensure principles are upheld. We also have the Paris Agreement, which I like to think of as a human rights instrument. And of course, that was a great day that we got that. Now, what is business and human rights law? As a commercial lawyer myself, the UN Guiding Principles on Business and Human Rights is a real favorite of mine. It was introduced in 2011. It is 3 pillars. The first is a state duty to protect. The second is a business responsibility to respect human rights. And the third is the duty or responsibility of state or business to afford access to effective remedy. And I underline effective there. The relevance of the UNGPs rapidly increase. To me, they are a tool, a legal and policy tool to realize the SDGs and help solve the climate crisis. And with 10 seconds to go, I would like to flag the use of a special procedure mechanism. Client Earth filed a complaint in 2021 against an oil major and its financiers. And as of last year, we received a response from the experts that formed that special communication group. They recognized and found that they expressed their serious concern for what they saw as a breach of different elements of the Paris Agreement, and they highlighted the duty of states to protect human rights by adopting and enforcing what they called a smart mix of laws, regulations, and policies, particularly under different human rights instruments. And it's the first time that UN experts have taken action to clarify the normative frameworks that we have in human rights law and apply them in a climate change context. And they are now being used in domestic litigation around the world, which you'll hear more of. I'm going to drop a link on that complaint in the chat. And with that, I hand back over to our moderators. Thanks so much, team.
Thank you. Thank you very much, Lara, for sharing those important perspectives on this important issue. We'll now be moving to our second question. Again, the question is, how does international law on climate change and human rights advance the global sustainable development goals? And to address that question, who better than Professor Ashanti Vitanaje and Professor Richard Walsgrove? I believe Professor Richard Walsgrove will be going first. Thank you.
Terrific. Thank you. Thank you all for allowing me to participate today. I always learn a lot at these CISDL events. So it's great to be here. I have to start with a caveat and say that amongst this particular group, I don't feel like much of an expert on international law. Much of my work happens here at the subnational level. So my plan, rather than trying to come up with my own ideas, is to share some wisdom that I have been the recipient of recently. One is through a meeting I had just this week with MPs of various small island states around the world. And I heard some really valuable lessons that I think relate to this question that you've asked, Ayman. And the second thing I'd like to share with you is some data points from last year's really illuminating report from the UNFCCC's expert group on synergies between greenhouse gas emission targets and the SDGs. So that's my plan. Here's what the MPs had to say. we're all looking for silver bullets when it comes to climate mitigation, and I think, sensible responses, there are none. The climate law, if we're trying to define it, I don't have Laura's three-part definition at hand. Climate law is this incredibly fuzzy world of international and national and subnational and local and community-based norms and rules and regulations, right? It's fantastically complicated, covers everything from constitutional rights all the way down to sort of the nitty-gritty fiduciary obligations of corporate actors. And so what does that mean to the MPs? They were looking at it in an opportunistic way and saying that climate law really can come from anywhere. And they were very interested to learn about how some of the recent climate litigation here in Hawaii, dealing with concrete climate rights, concrete plans to reduce emissions, actually relied upon really soft and fuzzy policy targets in Hawaii's law. Sound familiar? I mean, soft and fuzzy policy targets, that's the SDGs, right? We're talking about similar mechanisms there. And the MPs were also asked whether or not the SDGs influence their work on things like climate change when they're passing national legislation. And the answer was that the SDGs have been valuable, but they've been valuable in this sort of same normative and informational sense. They have access to information and data they didn't otherwise have access to, and that's shaping the decisions they make, even if it's not directly steering the outcomes. So I took away from that conversation with the MPs that we have these two incredibly fuzzy areas of law, right? The SDGs, this big fuzzy and overlapping series of targets and goals, climate law, this, right? Every law is climate law these days because it affects everything. How on earth do I answer your question, Ayman, and link the two, right? How do we find linkages between the two? And here's where I'll turn to the last year's report from the UNFCCC Synergies Group. If we just simplify climate law and say, okay, well, climate law, at least in one component, has this goal of reducing greenhouse gas emissions, let's model the co-benefits of that and figure out which of the co-benefits advance the SDGs. The evidence base explored in that report is mind-blowing. Everybody should open it up and read it. I'll give you just three quick examples. SDG 3, health. Air quality impacts are by far the most studied co-benefit of greenhouse gas emissions reductions. And something like 40% of the world's population can be brought into alignment with the World Health Organization's goals for access for exposure to particulate matter just through the existing GHG targets we have on the books today, right, through the existing NDCs. The cost-benefit ratio also modeled, like resoundingly positive. The money you put into reducing emissions pays back in health benefits for somewhere between, in a ratio of somewhere between 1.4 to 2.45, right? I don't understand why we don't do this all the time. Add in agriculture, SDG 2. Now, the entire global cost of GHG mitigation on a 2°C pathway can be sort of equilibrated by just the health impacts and the benefits to agricultural productivity that come from those emissions reductions. And the last one, because energy law is my thing, I'll point to a piece of data that suggested that electrifying the unelectrified across sub-Saharan Africa is expected to cost about $6 billion less per year if it's done in accordance with the existing NDC targets in the region. All right, so we're saving money at every turn. My last point, because I know we're on these 3-minute timelines here, the last point is that although I think that evidence base is important and it blows up this myth that climate law is about trade-offs and about losing something. Climate law is really about synergies and opportunities, in my view. The real harms of climate are not measured in dollars and cents like the evidence that I just described to you. It's measured in lives, right? The disruptions to lives. And so lives are saved through improving air quality, something on the order of 100,000 lives per year saved by 2030. Just from the existing NDCs. We ratchet that up and it's more than 250,000 or 350,000 lives per year saved through these air quality benefits. We're not accounting for an end of this monetization, the disparate impacts across geographies, across age groups, across genders, right? So we actually see that there are co-benefits there. And then we're also not accounting for all the costs. All these air quality studies that I've mentioned, they don't deal with health benefits that come from heat exposure, that come from child malnutrition, that come from economic damage from climate change, water scarcity. It just seems to me that we're living in this era where industry tells us all the time that we have to make hard decisions in order to solve the climate crisis. And I think that the evidence base out of this report suggests it's the opposite. It suggests that if climate law relentlessly accounts for all of these co-benefits, it's not that the climate law will advance the SDGs, it's that the SDGs and their co-benefits will advance climate law. And what a wonderful sort of virtuous cycle to find ourselves in. Thanks again for allowing me my 3 minutes.
Laura Richard, for sharing and contributing to very relevant and timely wisdom. You covered, among other issues, SDGs 3, 2, and 7. Dear Shanti, I have a sense you'll be focusing on SDG 5. Please go ahead.
That's right, Ayman. Well, greetings all, and I am really happy to follow on through with Professor Walgrove's theme of co-benefit and synergies, and kind of how to focus my comments today on the intersection between international climate law and the SDGs, in particular the SDG on gender equality. Now, as you all know, climate change does not discriminate, but its impacts are often discriminatory and sometimes gendered in nature. So, for example, you can think about how women represent 80% of people that are displaced by extreme weather. If you look at women and girls are often, in terms of their societal roles, often bear the role of water gatherers in various communities across Africa to Pakistan. And then during the time that extreme droughts is brought on by climate change, we see that the inability to access water means children are traveling further in search of water. And that's often at the expense of important education. We can look to the Pacific region and see how climate-related hazards like epic tropical storms, severe flooding, sea level rise, all of these have now ended up exacerbating gender-based violence. And so much of these social impacts from climate change are triggered by pre-existing gender inequities and power structures in society. So we see that climate change plays this role of a threat multiplier. We've heard that often. And in particular, this exacerbates existing gender inequities. At the same time, women also lead climate action. Women are more likely to join climate action civil society groups. They are often early adopters in climate conscious behaviors. They are first responders, caregivers during climate-related disasters. And of course, they also have specialized knowledge when it comes to nature-based solutions to climate impacts, especially given their prominent role in agriculture, subsistence farming, food production, wetlands management, and these are already raised by previous speakers as well. So gender considerations and inclusivity in decision-making is really imperative when it comes to ensuring that what we do in terms of climate action is holistic, inclusive, and successful. Yet, a lot of the gendered voices are seldom heard at the decision-making level. And one of the examples that came out from some of the data that came out in COP28 was looking back at data from COP27 in 2022, which showed that 63% of delegates were men, 37% were women, and then alternate genders were disregarded entirely in the count. So when it comes to international legal frameworks, we need to really think about how can we
I'm afraid we may have lost connection with Shanti. Just checking if it's just me, but I cannot hear her anymore.
Yes, I think none of us can hear her. Perhaps we can come back to her and...
Okay, let's do that then. So I'll be happy to move back to those important remarks about the ability of SDG 5 to improve climate action. And as Ashanti was sharing some very thought-provoking and impactful data in support of some issues that need to be addressed. Moving on to the third question of the focus questions, and looking at Professor James R. May and Advocate Zunaida Musa Wadiwala, for them to share their perspectives on what have been the most recent developments in climate litigation worldwide, and what are some challenges and opportunities in that regard. James, as you were sharing your thoughts, Zunaida, go ahead, please.
Okay, I was just saying thank you so much, Ayman, and thank you to Ashfaq as well. So in the 3 minutes that I've been allocated, I think it is absolutely necessary for me to say that we are just past midway 2024 or mid-year 2024, and we have already seen exciting human rights-based climate litigation milestones around the world. Most impactful for these, for example, the 21st of March 2024, where a 3-judge Supreme Court bench in India formulated a new constitutional right to be free from the adverse effects of climate change. And this was done by drawing upon the fundamental rights to life, personal liberty, and equality in the Indian Constitution. This was then followed by the advisory opinions by the Inter-American Court of Human Rights and then ITLOS in April and May, respectively, with the tribunal having noted that climate change represents an existential threat and raises human rights concerns. What I would particularly like to discuss, though, is that on the 9th of April, 2024, the European Court of Human Rights adjudicated its first 3 human rights climate claims, with potentially huge repercussions for climate justice in Europe and beyond, by recognizing that the climate crisis is a human rights crisis and that governments must significantly increase their climate efforts in order to protect human rights. The 3 cases were the Swiss senior women's case, Clima Signorinen, the Portuguese youth case, Duarte Agostino, and of course, the French mayor's case, Krim. Now, the latter 2 cases were not admissible due to procedural challenges. And I think these issues are what we need to challenge, or what needs to be challenged. But what is of significance is that the courts showed willingness to engage with the arguments, illustrating the magnitude of the climate crisis and its connection to human rights. It is apt, therefore, to turn back to 20th of December 2019, where the Netherlands Supreme Court in Agenda, particularly renowned for being the first judgment in the global north to support climate change claims under human rights law, and to thus establish a legal duty of a state to increase climate ambition. This then takes us back to 9th of April 2024, where we link that these human rights violations, particularly Articles 2 and 8 of the European Convention of Human Rights, the right to life and the right to respect for private and family life, were attributed to the Swiss government's failure to implement a regulatory framework in accordance with its Paris Agreement commitments to reduce greenhouse gas emissions. Of relevance then to your question, Ayman, by finding that climate change is affecting human rights at present and in the future, the court affirmed that weak climate action by a state, and the court then identified lacuna in its domestic frameworks, is actually a violation of its human rights obligations to protect plaintiffs from the harms of climate change. Thank you very much.
Thank you very much, Zunaida, for taking us for traveling with us about this important issue and showcasing concrete examples of positive progress in that regard. Equity matters, and including equity between speakers. So if you don't mind, I'd like to go back to Ashanti to give her 1 minute so that she may conclude her intervention, and then very keen to hear about Jim's perspective on this as well. Thank you.
Thank you so much for coming back to me, Ayman. So I just want to go back to the international climate regime has really come forward in terms of looking at addressing gender equality. And we've adopted over 80 decisions with gender-related mandates. And if you look at even some of the various outcomes, like the Paris Agreement, you'll notice a rise in gender-responsive language. That, of course, is including language enough, and that is one of the kind of issues that we are facing. But in terms of what national climate change law offers, existing monitoring and implementation frameworks, such as the nationally determined contributions, CDCs, already have opportunities where we can translate that language into action. And we've already seen it happen where such as Samoa and Fiji doing that in terms of taking that in national policy, putting it into NDCs, and then that actually ending up in national security policy that matches climate change with gender equality goals. And of course, we also had the most recent COP in Dubai, which started to, which had was notable for selecting gender equality as one of its thematic days. And so for one day, all pavilions in the Blue Zone turned their minds to the gender dimensions of climate change. But of course, this was just one day in the Blue Zone, right? It was also external to the negotiations where the decisions were being made. So we'd be hard pressed to kind of regard that as really meaningful integration of gender considerations in the making of the national policy on climate change. We're thinking about how do we better advance SDGs like SDG 13 on climate action and SDG 13 on 5 on gender equality. We really need to critically assess what it means to meaningfully integrate these SDGs and respond accordingly, not superficially, right? So I will end my remarks on one point. Ultimately, the integration of gender considerations and the elevation of gender voices in negotiations and decision-making halls can't really be left just to the spaces of international climate law. And as Professor Walsgrove mentioned already, there is this ecosystem of climate law that takes place at various levels of governance. And so we need to have integration of gender considerations taking place throughout that ecosystem in order for climate action to be truly inclusive, holistic, and successful.
Thank you. Thank you very much, Ashanti. I'm now honored and pleased and delighted to give the floor to James for his perspective on question 3. Thank you.
Okay, let me begin by, is the audio okay? Can you give me a thumbs up? Okay, great, everyone. So good morning, good afternoon, good evening, wherever you are. Again, thank you, CISDL. It's just a pleasure to be a part of this. And I'll be talking about climate litigation in the United States. So my remarks follow up nicely on what you just heard from Chinthi and also Zenaita's terrific comments about climate litigation around the globe. But my remarks will be at the junction of SDG 13 on climate action and SDG 15 on peace, justice, and strong institutions with a focus on US cases. So here we go. So let me begin with the federal level. The news isn't great from the United States. The leading case is Juliana versus the United States. In that case, compressing a lot of background, the Ninth Circuit held that the plaintiffs lacked standing to challenge the government's climate policies as violating a fundamental right to a stable climate under what's called the Due Process Clause of the U.S. Constitution. And on remand, the trial court allowed the plaintiffs to amend their complaint to seek a declaration that government policies contravene this fundamental right to a life-sustaining climate. The Biden administration opposed that, and it went back to the Federal Circuit Court, and the Federal Circuit Court dismissed the case on July 12th. So for now, the case has reached its end, and the Circuit Court also denied the plaintiff's request for reconsideration, what's called en banc, before the entire panel. So for now, that case is finished. OCT, Our Children Trust, has also filed other federal cases, including one with similar claims against the U.S. Environmental Protection Agency, and that one is just getting started, but there's not much else to report from the federal level in court about climate rights. At the state level, it's different. The news is better, but still not great, but it has a lot of potential. And so I'll focus on 4 leading cases. I'll begin and end with Hawaii. Really, that should be what Richard is doing, but I'll stop off in Montana and New Mexico along the way. First, Hawaii. Settlement, the first of its kind, in a case called Navahin versus Hawaii Department of Transportation. And in this action, the plaintiffs claimed that the state's practices of favoring fossil fuel-based transportation infringed their right to a healthy environment guaranteed by Hawaii's constitution. And just last month in June 21st, the parties settled the case, establishing a new climate change mitigation and culture manager and a goal to achieve zero emissions in all ground transportation and air and sea transportation by 2045. It's an incredible case. It's the first settlement with the government to enforce a right to a healthy environment anywhere. And it's the first to reach and settle a case about a right to a healthy climate anywhere. The next case is held. It's out of Montana. There was a trial a year ago, about 13 months ago, about climate, the first time climate had been put on trial in U.S. history. And the lower court, the district court, held that the state had violated the state's right to a healthful environment, guaranteed by the Constitution of Montana. So the state appealed that case, and oral arguments were held on July 10th, so just a couple of weeks ago. So we'll see what happens, so stay tuned. The next case is out of New Mexico. It's at Atencino versus the state of New Mexico. And it's not about a right to a healthy environment, because New Mexico's constitution doesn't have that. But it is about a right to life and other provisions of the Constitution. So that action is underway. The lower court, the trial court, upheld the plaintiff's constitutional claims that the state was abridging its obligation to prevent despoilment, it's called, of the climate. And on June 10th, the trial court of the state denied the state's request to dismiss the case But that has been appealed as well through something called interlocutory appeal. So it's moved up. So stay tuned. We'll see what happens. The fourth and final subnational case brings us back to Hawaii. And the one that I'm most concerned about is Honolulu versus Sunoco. So it's Honolulu, the city and the county, and the water district against carbon majors. Again, this time, though, for common law claims for nuisance and negligence and trespass. Well, again, a long procedural history, but let me just shorten it by just saying that Sunoco has asked the U.S. Supreme Court to intervene. So it's the state Supreme Court has upheld the plaintiff's right to bring these common law claims, found that the court has jurisdiction, the plaintiffs have standing, but the carbon majors have asked the Supreme Court to decide this question. Here you go, I'm quoting, whether federal law precludes state law claims seeking redress for injuries caused by the effects of greenhouse gas emissions on global climate. What that means is they're asking the U.S. Supreme Court really to throw out all state-based claims in common law, but potentially in constitutional law as well. The Supreme Court asked the Biden administration to weigh in, and it hasn't yet. So we'll see what happens. But a grant of certiorari in that case could potentially leave no state actions available to address climate change. And coupling that with the lack of federal actions, there's lots of room for concern. So that's my recap. Those are my few minutes. Thank you so much.
Thank you. As you concluded your remarks in Hawaii, mahalo nui loa to you too, James. We'll certainly be staying tuned for more developments. I'm also seizing the opportunity to, again, invite our dear participants to engage through the Q&A, asking questions, making comments if they so wish. It's a very rich topic, and very delighted to have amazing experts discussing it. We'll now move to our interveners, and we have two of them that I'll be introducing now. William Shipley is a US-based attorney who has previously practiced in areas of international labor rights and development, inter alia, with the International Labor Organization, International Human Rights Law for Amnesty International, etc. He has published on the intersections of human rights law, among other topics, and he is the Human Rights Program Coordinator for CISDL. Advocate Maeve E. McDermott is the Climate Law and Governance Initiative Manager at the Center for International Sustainable Development Law. He also serves as Program Manager for the very cool initiative called the Democratizing Education for Global Sustainability and Justice Program based at the University of Cambridge. The fact that I say this one is cool is not implying that the others are not cool. I just happen to be quite engaged and interested in this one. So, Advocate Bill Shipley, your intervention, please. Thank you.
Thank you, Ayman, and to all of our speakers today, and to those members of our audience attending. As has been noted, there's really a great deal of complexity in the international human rights regime writ large, and given that, what's the role of education in advancing human rights? And are there particular constituencies or stakeholders for whom human rights education may be particularly important? That's just a general question for our panelists. Thank you.
Thank you very much. Now the floor is to Maeve.
Thank you so much, Ayman, and thank you so much to all of the speakers for this informative discussion. In the interest of time, I'd also like to use my intervention to ask a question to the speakers. The 28th Conference of the Parties to the United Nations Framework Convention on Climate Change was hailed by many as historic for its outcomes on fossil fuels and for the Loss and Damage Fund. However, the COP28 outcomes also received heavy criticism for being insufficient and flawed. Could you please discuss some of the key developments at COP28 integrating human rights in climate policies, and perhaps some of the obstacles as well? And could you also please discuss what needs to be done at COP29 to protect and advance human rights in the face of the worsening climate crisis?
Thank you very much, Maeve. I know Gwyneth and Antoinette, who introduced us to the session, and Ashfaq and I very warmly earlier, have also been keenly monitoring our online forum for questions. Would you be in a position to share some questions from the audience before we revert back to our panel? Thank you.
you, Ayman. Yes, we've had actually comments and questions from Nigeria, the Philippines, Israel, Barbados, Kenya, Nepal, Bolivia, Nigeria, Barbados, Ghana, and so we've basically summarized them all into one basically pack. So we have Jogendra Raj Rujal from Nepal, Dr. Donna Green Rushigi from Barbados, and Shmuel Hiroshimi from Israel. And the question is as follows: is how can linking human rights with climate change efforts effectively address poverty, improve social and economic well-being for poor and low socio-economic groups, ensure genuine inclusion of less developed nations in global initiatives, and protect vulnerable populations from the life-threatening impacts of climate change? And I have said I put them all into summary, so the people asking the questions, they may recognize some of the questions. Thank you.
Yes, and
thank you.
finally, apologies. Yeah, we have a sort of a second group of questions around climate litigation. So I think some of our speakers would be sort of well positioned to ask or answer these rather. So we have Tiffany from Cochabamba, Bolivia, Esther from Nigeria, as well as some anonymous speakers who wonder about how to leverage the recent developments in domestic climate litigation in order to strengthen the international sustainable development goals. So thank you.
Thank you very much for collating those questions in a manner that is quite effective while still keeping true to the essence of the questions that were asked. Much appreciated. Thank you. So we'll now be reverting back to our panel, and I'm happy to give the floor first to Lara, if she'd like to come in and address some of the questions that were raised, be it from our interveners or the recap from the online Q&A that was aptly provided just now by Gwyneth and Antoinette.
Absolutely. Well, I'll just give a few thoughts there and then hand over to people that certainly have more expertise than I do. Just on the intervention around education, I think absolutely everyone should have the opportunity to be educated on human rights, whether you're a very young person starting schooling for the first time at kindergarten or you are a lot older, and it should be integrated into all policy. And I speak, I'm Australian, and certainly without a Federal Human Rights Act or being part of any bigger supranational framework, that would be hugely helpful. On what we'd like to be seeing at COP29 and COP30, as someone who's come outside the UNFCCC machinery, having been in a law firm and then kind of come into it all, you know, forgive me for anyone who's been on this journey for a long time, and certainly there are many on this call who have. What I would love to see, and I know what a lot of other people would want to see, is a day specifically dedicated to law, a law day that would allow us to focus and look at practical examples of the implementation and the structural changes that are needed to realize the goals of the Paris Agreement, the SDGs, and really skill up and use the tools we already have to amend policy and really look at, I guess, from all perspectives, that toothier aspect. And I appreciate that the term law might not be one that is welcome, and that climate justice is something that is preferred. But as we enter this stage, and with the science as scary as it is, I think that perhaps we could move into a law day. So that would be my remarks. Hand back over. Thank you.
Thank you. Thank you very much for sharing those important remarks. Now I'd like to hear from Richard and then Chanti how they would like to react to what we've heard from our interveners and participants, or maybe the other speakers as well. Thank you.
It's such a rich set of questions and comments. It's difficult to figure out where to put one's emphasis in trying to address these issues, and far be it from any of us to be able to magically decide exactly what COP29 should deliver. And so I think I'll just return to a similar theme and say that in response to every one of these questions, and in response particularly to this question about what do we hope to see on the human rights front in COP29, I'd like us to just take a step back and ask whether or not the entire sustainable development framework sort of starts from what was once, I think, a solid foundation that we must inherently deal with net negative trade-offs in order to promote things like human rights, or to promote things like sustainability. And that's because the developed world and the industrial world has written the laws for centuries. And of course, we want to start from a perspective that says the way it's always been is the way it should always be, and woe is us if we make any changes. And I ask that all of us just flip that on its head and recognize that when you're talking about something as fundamental as human rights, or we're talking about something as fundamental as the right to a life-sustaining climate system, that it's not a net trade-off at all. That there are trade-offs to be made, but it's a net benefit. It's a net benefit under any metric. And if we start from that perspective, perhaps we can unstick some of these log jams. I just don't want us to assume that these are mutually inexclusive trade-offs between sustainability and human rights.
Well, thanks, everyone.
Thank you very much. Going to Ashfaq now. Yes.
Thanks, Ayman. I agree with Richard in terms of the richness of the questions that have been posed by everyone. I think I'll go through some of them quickly. In terms of the role of education as an educator, I think it's not surprising that I do feel that there is a strong role for educators at every level to play, and it's not just also formal education institutions or primary institutions, it's also through more non and more formal educational things as well, such as, for instance, one great example is like radio talk shows that have been utilized in terms of supporting climate resilience among low-income communities that don't necessarily have access to some of the other more formal educational systems. So there's already a curriculum on education for sustainable development that has been set up by the UN, and that resources that can be tapped into by anyone around the world. We're also seeing in terms of the legal education system and legal curriculums adapting to how the climate crisis and sustainable development needs are being introduced. So, for instance, the Queensland University of Technology in Australia has now embedded sustainability throughout its entire curriculum, and so that's happening in other places across the world as well. In terms of Maeve's question about COP28, and some of the outcomes from it, I think one of the outcomes I would raise is, especially considering I spoke about gender equity, is that there was a launch of a partnership on gender responsive justice transitions and climate action. And this has been endorsed by 82 parties. Not enough. I think we need everyone on board, and we think this partnership is meant to look at things like finance, data, opportunities. And I think that leads in nicely to what needs to be done with COP29, especially with climate finance, to be specifically integrating gender considerations in how they do address climate finance. And then, of course, in terms of effectively addressing poverty, I think, again, the gender considerations have already shown that having those in mind has led to more significant economic outcomes, and that in turn can lead to bringing folks out of poverty. It's another area that we can see those linkages between all these SDGs and how there are synergies that we can really build on and co-benefit.
Thank you. Thank you very much. I'd like to also indicate to our dear participants that some of the questions are being addressed directly in writing by our speakers, so to keep an eye on the Q&A for some of those questions to be addressed directly in writing. Now, looking towards Neda for her perspective on those important questions. Thank you.
Thank you so much, Ayman. And I'm looking at the questions that were posed by the interveners, and I've sort of come to one answer that could hint on addressing both those questions. So firstly, with regards to education, and I'd like to draw here from Professor Ian Frey's report in the context of climate change and human rights, where he reviewed barriers for climate litigation, and he found a lack of training by the judiciary on climate change and human rights matters. And his report, in fact, called for a simple and accessible multilingual guidebook for judges on the science of climate change. We also saw happening at COP28 in the Blue Zone a firm commitment by many universities to include climate change and climate litigation education within the context of human rights into their curriculum. And then lastly, we also saw during COP28 and at Climate Law and Governance Day, which concluded with massive and unprecedented global investment and cooperation from many legal and governmental organizations globally. And they confirmed that working hand in hand with governments to enhance the goals of the Paris Agreement, lawyers, businesses, and others all then pledged hands on deck to find sustainable solutions. Thank you.
Thank you. It's all about solutions. Better be than be sustainable. James, the floor is yours. Thank you.
Yeah, okay. Thank you for the questions. I'll just focus on two of them. One is Marcus's question about how a Harris administration might change the dialogue about climate and its effect on climate litigation in the US. He asked whether there'll be more of it or less of it. You know, for me, I mean, who knows, right? I don't, but here's my guess. If I had to guess, I would say no, it won't lead to more litigation, even if the Harris administration is less climate centric than the Biden administration. I mean, the Biden administration has done more on climate than any other administration in American history. And some of that no administration can undo, only Congress can undo. It's called the Inflation Reduction Act, but it's really a climate law. It's to throw lots and lots of money at renewables and other means to lead to a net zero, or at least a reduction of carbon emissions. So I would see a Harris administration abiding by that, implementing that, and kind of continuing along the same route. Why I don't think there'll be more litigation is our Supreme Court. So the U.S. Supreme Court has been, sort of remarkably hostile to climate cases. It's hostile to environmental cases in general, but remarkably so anything about the climate. It struck down the Obama administration's clean air plan. It's just anything that comes up. It's the Supreme Court is not favorably inclined to advance climate cases. So that trickles down through the whole federal system. That's why state constitutions and state laws have increasing import. So that's the first question. The second question just gets to, what the value of climate litigation, and especially climate rights litigation, and its connection to SDGs. And I would say that the jury is still very much out on that. There are these notable cases that we talked about, but when we look overall across the planet about whether they're reducing greenhouse gas emissions, there's not much evidence that they are. Switzerland's not following the senior case. Shell has appealed the Dutch case. There are no cases out of the US on climate rights really at the federal level. So anyway, that might suggest again that we need to have a multilateral agreement that has enforceable limitations that the Paris Accord doesn't, and refocus our efforts on global responses rather than rights-based responses.
Thank you for that. It's actually quite interesting. In the Q&A, we've seen comments from Shukrat from Nigeria pointing to the failures of the Nigerian judiciary. It just really shows that the point about there being no silver bullets that Richard said is really important, and that the situation and the possibilities for human rights law are going to vary remarkably from jurisdiction to jurisdiction. And so in some places the matter can only really be addressed through legislation, whereas in others the courts have an important sense. And it'll also be a question not only about judicial attitudes, but also sometimes the law, the extent to which international law has been domesticated and which areas of domestic law have been reflected. In terms of moving forward, Shmuel asked about how is poverty going to be addressed as we deal with human rights and climate change. And that's the question of whether economic, social, cultural rights are legally enforceable in a particular jurisdiction are going to become really, really important as to questions as to whether litigation leads to a just transition, or in some cases addresses only some aspects of the problem. I think we're going to be seeing a lot more litigation about what forms of mitigation are going to be required legally, not just the overall amount. Let me turn very quickly as we come to a close to our keynote speakers and see if they would like to add any points or address any of these questions that have arisen.
Yeah,
Go ahead, please, Justice.
I think the world is now looking at the litigation. It started from the south, then picked up by south and went to north and west too. As you can see, what's the concept now called a copycat cases. One country, the cases for mitigation, some cases for adaptation, and different kind of cases are coming into it. And the judicial anthropology of climate justice litigation in the world is now focusing towards which area to focus. Right now, the Supreme Court of Pakistan has just shared in the group a judgment given by Justice Masuri Shah, which is also in the group on environmental constitutionalism and the Islamic environmentalism. A new concept is coming out now after the Asghar Laghari case is how the courts will be looking into it. And my focus is always only on the issue as what has been done, damage has been done. The only way to undo is we need finances. And that is what the article of the Paris Agreement, and there's a commitment, and because we are now in a stage of now that we cannot talk about soft laws. The COPs and all, they're all soft laws. There's no binding international agreement. There's no binding international obligation to any state. Unlike the Agenda 21, unlike the Earth Charter, there's nothing like this which we can obligate our countries to do, because we are all in the one globe. And the only issue is right now, Supreme Court of Pakistan is hearing a case of looking into how to look into the climate finance issues. I am hearing a case where a case came to me by a donor which gave a lot of money for climate finance for the carbon sink. But then what happened was the person was doing something else, not what the project was. So I then stayed the whole project and I directed him to go back and have lots of forests to be planted because they're easy for adaptation than difficult for mitigation, because that requires a lot of billions of dollars of funding. So my only point to conclude is that now we are looking at some donors. We have huge conference coming in Pakistan. My whole focus is now on the climate finance and the legal framework. And I got so many partners. I spoke in London the last 2 weeks. We've been speaking it. The whole issue is that how the commercial courts and the international commercial arbitration, because the best lesson is the international arbitration failed in Ecuador of the China mining case. What is happening in some finances, every business school on the first day are telling all the leaders of the world to first look at the issue of climate justice in their projects, because huge projects are now being stayed by the world. And now we should only talk about one thing called climate finance, because no talk, we have to walk. Thank you.
Justice Hassan, and the role of courts in climate finance, is there a major role, or do you see this all to be addressed?
That's what the main role would be, because climate finance can be looked into by the district judges, can be seen by the High Court judges, can be seen by the Supreme Court judges, and now we have the bodies of the commercial court judges and the body of environmental court judges. And now both are now thinking that we should now be educating each other, because tomorrow these issues can come. Now I meant because the courts are dealing with it, but courts need more support and more knowledge from people like you. That's why we are having partners coming out. We had a huge conference in Pakistan on climate change. I spoke on climate finance. And from there, we got 2 more issues coming in. Because countries like Pakistan, which is something the worst, have focusing only on the money to be spent how. And that's the only security I give to the donor is the courts will protect their funding. Courts will strengthen their confidence, and courts will not let the project go anywhere except climate justice and for climate mitigation and adoption.
Thank you very much. And Ambassador Williams, if you wanted to have the last word from law to a politician. You're on mute.
Thank you. I muted to get clarity on audio side. I'm impressed by what I've heard this morning. I've learned a lot, and I'm glad that there's such an array of talent directed at various aspects of this problematic that you threw at us. I want to say that I welcome the conversation around the fact that the SDGs are both facilitator of climate action and likewise that climate action have a role to play in the achievements of the SDGs. Now, as regards the courts and litigation, someone said it is moving from the south to the north and all around. There are the case of Vanuatu, the Pacific Island students in Vanuatu. I think it is particularly pivotal and particularly exciting because it picks up in a legal way the arguments that people like me made for 20 years, that, you should. Well, they take it to the courts so that hopefully the courts will say you must. So that part is important. And as Justice Hassan says in relation to finance, which I'll come to, I think for the CIDS, the finance is critical, whether it's discussed as climate justice or other language. The finance is the key. It is the silver bullet. Grenada holds the executive directorship in the UNFCCC, and it is his island, it's Simon's Island, that has been devastated as part of Grenada. And he came to Grenada some months ago and talked about, is there a silver bullet? And if there is one, it is the adequacy of the climate finance beyond the 100 billion that was promised that isn't yet fulfilled. However, by my thinking, if we are not able to get climate finance in the quantum and across the climate change agenda, then we have put in the South some initiatives on the table, like the Bridgetown Initiative, basically reforms in the existing architecture that say, for example, that there can be a climate action adjustment to repayment of the debt overhang that we experience. So in our case and cases of Barbados and many other, Jamaica, others who have experienced the hurricanes, we are calling for a suspension in debt repayment at a time of national climate-induced disaster. So that's a way, it's a circuitous way of getting around perhaps innovative financing. I think reforms also in the Security Council of the United Nations matter because they do help to steer a greater and higher scale of action from the Council. If the veto is not available to be used as it is now in some cases. And lastly, I want to endorse the call for more education. I think that is key, not just for jurists and justices, but also for politicians, for legislators, so that we could be a little bit more agile and robust, in paying attention to both the national and the regional possibilities as is needed in the new arrangements for SIDS and for other vulnerable states building resilience. So thank you for this.
Thank you very much. And on the last one, I think we can do it, as with all of the partners involved in this symposium. It's really helpful to hear you say that. Okay, now we'll thank you to all the speakers. It's been a rich discussion. Thank you for all those posing questions. Hopefully, we've answered some of them either in verbally or in the chat. So the next plenary is already starting, or it's going to be starting shortly. So the addresses from Professor Ian Fry and Professor Sumdu Atapatu, those will actually be doing them at the closing plenary. So please look out for them. They're, of course, giants in the field and will be worth listening to. So coming up now.
I want to thank you for inviting me to speak at this important meeting. On the issue of linking human rights and climate change through international law, I'd like to briefly talk on 5 thematic areas. First, I would like to refer to the advisory opinion of the International Tribunal on the Law of the Sea. The tribunal was clear when it stated that given the risks posed to the marine environment, states in fulfillment of their obligations under Article 192 of the Convention are required to take measures as far-reaching and efficacious as possible to prevent or reduce the deleterious effects of climate change and ocean acidification on the marine environment. It goes on to say, where the marine environment has been degraded, this may require restoring marine habitats and ecosystems. This obligation is one of due diligence. These two elements give a clear direction to parties to UNCLOS and to non-parties who recognize key elements of UNCLOS as customary international law, that they have an obligation to take measures as far-reaching and efficacious as possible. An absence of such measures clearly gives rise to opportunities for disputes under ITLOS and other tribunals. I envisage that we will start to see such disputes arise fairly soon. Second, I want to refer to the International Law Commission's second issues paper on sea level rise in relation to international law. This issues paper raises many legal contentions and notes that the work of the Security Council, General Assembly, United Nations bodies, and various international and regional courts and tribunals in addressing matters relating to sea level rise. The study group refers to the Montevideo Convention and various perspectives regarding the creation and maintenance of statehood. Notably, the report states that the current international legal frameworks that were potentially applicable to the protection of persons affected by sea level rise were fragmented, mostly not specific to sea level rise, and required further development. This is where we all must stand up and work towards developing international law for the protection of persons affected by sea level rise. Perhaps we, in the international law community, need to develop a UN General Assembly resolution that clearly states the obligations of states to protect people affected by sea level rise. I will certainly be looking at this issue. Third, I want to refer to the UN General Assembly Resolution 60/147, called Basic Principles and Guidelines on the Right to Remedy and Reparation for Victims of Gross Violations of International Human Rights Law and Serious Violations of International Humanitarian Law, which was written in 2005. The resolution states that remedies for gross violations of international human rights law and serious violations of international humanitarian law include the victim's right to the following as provided for under international law. 1, equal and effective access to justice. 2, adequate, effective, and prompt reparation for harm suffered. And 3, access to relevant information concerning violations and reparation. It is my view that the actions of key fossil fuel companies are perpetrating gross violations of international human rights law. We should be using whatever means possible to hold fossil fuel companies legally accountable for their violation of international human rights law and be seeking adequate, effective, and prompt reparations for harm suffered. Fourth, I continue to be concerned about the plight of people displaced across international borders due to the impacts of climate change. These people are not defined as refugees and, in my view, fall through the cracks as far as proper legal protection is concerned. In my report, when I was Special Rapporteur to the Human Rights Council last year, I recommended the Human Rights Council prepare a resolution for submission to the UN General Assembly, requesting the development of an optional protocol under the Convention relating to the status of refugees. Needless to say, I received mixed response to this proposal. Nevertheless, the number of people displaced across international borders due to climate change is growing. We must give proper protection to these people. Fifth, we are witnessing a global crackdown on groups and communities protesting against the lack of action on climate change. People are dying as they bear witness to the climate emergency. I heard horrific stories of Indigenous peoples in the Philippines who have witnessed extrajudicial killings because of their concerns about climate change. In my report to the UN General Assembly in 2021, I suggested we needed an international legal procedure to give full and effective protection to environmental and Indigenous human rights defenders, including establishing an international tribunal for the prosecution of perpetrators of violence and death against environmental and human rights defenders. Such a tribunal is urgently needed. So thank you very much for listening to these 5 points. Hopefully they will trigger further action on these important issues. Thank you.
Hello, my name is Sumodu Adapatto and I'm the lead counsel of human rights at CISDL. I'm also a teaching professor at University of Wisconsin Law School. I'm sorry I'm not able to join you live today, but I'm pleased to send you some closing remarks. The link between climate change and human rights is no longer disputed. From severe weather events to sea level rise, climate change is causing massive disruption in the lives of people around the world. While no nation or community will be spared these consequences, not all nations and communities will experience these consequences equally. Historically marginalized communities, poor people, and poor countries will experience these consequences disproportionately, even though their contribution to climate change is insignificant. Although climate change poses an unprecedented threat to the enjoyment of rights, the human rights framework offers a potential avenue to victims of climate change to seek relief and hold states accountable. Moreover, action on climate change can involve human rights, especially the right to health. Many of the victims of climate change are poor and marginalized segments of society, and the human rights framework has given them a voice. The recognition of a standalone right to a healthy environment by the UN General Assembly is significant in this regard. It has given victims of climate change a solid footing to seek redress under the human rights framework. While human rights courts and treaty bodies should be commended for their groundbreaking decisions, more work needs to be done to flesh out the parameters of the right to a healthy environment and the obligations of states, both under human rights law and international environment. So what is the role of Sustainable Development Goals? Climate change undermines the realization of SDGs, especially SDG 1 on poverty, SDG 2 on hunger, 3 on health, 5 gender equality, and 10 on reducing inequality. Verse 13 on climate change. What is the role of international law and what are the challenges? To give a few of these, as international lawyers, we need to develop collective theories of liability, expand the scope of extraterritorial obligations, rethink the local remedies rule for something as complex as climate change, expand the protection to cover climate refugees, address the legal and humanitarian issues surrounding small island states, consider how to incorporate human rights into NDCs, adaptation measures, and the loss and damage mechanism, and rethink the role of non-state actors such as major emitters for the damage they continue to cause. These are some of my thoughts. Obviously, we cannot cover all of the challenges in a few minutes, but we should give some food for thought. Thank you very much.